Most gun owners thought they understood the rules. For decades, courts across the United States relied on a familiar legal test, one that allowed governments to balance gun rights against public safety concerns. That approach shaped everything from concealed carry laws to restrictions on certain types of firearms. But in 2022, the United States Supreme Court did something unexpected. It didn't just tweak that framework, it replaced it entirely. And in doing so, it fundamentally changed how courts evaluate gun laws across the country. Almost overnight, long-standing regulations were thrown into legal uncertainty. Cases that had been settled for years were reopened. Lower courts were forced to rethink everything, from magazine limits to licensing requirements. The question now isn't just what the Second Amendment protects, it's how far that protection goes, and who gets to decide. So here's the question I want you to think about. If courts can no longer balance public safety against gun rights the way they used to, what should determine whether a gun law is constitutional? Let me know your thoughts in the comments. Because to understand why this decision matters so much, we need to step back and look at how we got here. For most of American history, the Second Amendment wasn't interpreted the way many people assume today. The text itself is short. The right of the people to keep and bear arms shall not be infringed. But for generations, courts debated what that actually meant. Was it an individual right? A collective one tied to militia service? Or something in between? It wasn't until 2008, in a landmark case called District of Columbia versus Heller, that the Supreme Court definitively recognized an individual right to possess firearms for lawful purposes, like self-defense inside the home. That decision was groundbreaking, but it also left a lot unresolved. Because while the court said individuals have a right to own firearms, it also made clear that the right is not unlimited, and that created a challenge for lower courts. How do you decide whether a specific gun law, like a permit requirement or a restriction on certain weapons, is constitutional? To answer that, courts developed what became known as a two-step framework. First, they asked whether the regulated conduct fell within the scope of the Second Amendment. If it did, they moved to step 2, applying a form of scrutiny, often intermediate scrutiny, to weigh the government's interest in public safety against the individual's right to bear arms. In simple terms, judges were balancing, on one side, constitutional rights, on the other, public safety concerns. And for over a decade, that balancing approach shaped gun law across the country. Then came the case that changed everything: New York State Rifle and Pistol Association versus Bruen. At issue was a New York law that required individuals to show proper cause to obtain a license to carry a concealed handgun in public. That meant you couldn't just say, "I want to carry for self-defense." You had to demonstrate a specific need, something beyond general concern. The Supreme Court struck that law down. But the real impact wasn't just the outcome, it was the reasoning. The court rejected the entire two-step balancing approach that lower courts had been using. Instead, it introduced a new standard rooted in history and tradition. According to the court, when evaluating a gun law, judges must ask a different question. Is this regulation consistent with the nation's historical tradition of firearm regulation? If the answer is yes, the law can stand. If not, it's unconstitutional. No balancing, no weighing of interests, just history. And that shift is enormous, because now, instead of asking whether a law is reasonable or serves an important government interest, courts are digging into historical records, sometimes going back to the 18th or 19th century, to find analogs. Let's make that more concrete. Imagine a modern law restricting high-capacity magazines. Under the old framework, a court might ask, does this law help reduce gun violence? Is it reasonably tailored? Under the new framework, the question becomes, is there a historical tradition of regulating weapons in a similar way? That's a very different analysis, and it's not always easy to answer. Historical records are incomplete, context matters, and reasonable minds can disagree on what counts as a relevant analogy. This has led to a wave of legal challenges across the country. Some courts have struck down long-standing regulations, finding no clear historical precedent. Others have upheld similar laws, pointing to broader traditions of regulating dangerous or unusual weapons. So we're now in a period of legal uncertainty. And this is where a common misconception needs to be addressed. Many people assume that this decision means all gun laws are now unconstitutional. That's not accurate. The Supreme Court was explicit. Certain long-standing restrictions, like bans on firearms for felons or laws prohibiting guns in sensitive places, remain presumptively lawful. What's changed is not whether regulation is allowed, but how courts evaluate it. Another misconception is that history provides clear answers. In reality, historical analysis is often complex and contested. For example, what counts as a relevant historical analog? Does a law from 1791 carry more weight than one from 1868? How similar does a past regulation need to be to a modern one? These are open questions, and different courts are answering them in different ways. That's why you're seeing conflicting rulings across the country, and it's likely that the Supreme Court will have to step in again to clarify. In my analysis, this shift reflects a broader debate about constitutional interpretation. Some judges and scholars believe that the Constitution should be interpreted based on its original public meaning, what the text would have been understood to mean at the time it was adopted. Others argue for a more flexible approach that allows for evolving standards and modern realities. The Bruen decision clearly aligns with the historical, or originalist, approach. Supporters argue that this method protects constitutional rights from being eroded by shifting policy preferences. They say it provides a more objective standard grounded in history rather than subjective balancing. Critics, on the other hand, raise concerns about practicality. They argue that relying heavily on historical analogs can be difficult in a modern world with technologies and social conditions that didn't exist centuries ago. They also point out that historical records may reflect outdated or incomplete perspectives. Both sides raise important points. And this isn't just an academic debate. It has real consequences for everyday people. Consider something as simple as carrying a firearm for self-defense. In some states, licensing systems have been significantly relaxed following the Bruen decision. In others, new laws have been enacted to redefine sensitive places where firearms are prohibited. The legal landscape is changing in real time, and if you're a gun owner, or even someone who isn't, these changes can affect where firearms are allowed, what restrictions apply, and how laws are enforced. It's also important to emphasize that this discussion is for educational purposes only. If you have questions about how specific laws apply to you, it's always best to consult a qualified attorney in your jurisdiction. Now, here's something else worth considering. The Bruen decision didn't exist in isolation. It builds on earlier cases like Heller and McDonald versus City of Chicago, where the court held that the Second Amendment applies to the states through the 14th Amendment. Together, these cases form a framework that continues to evolve. And we're still seeing the ripple effects. For example, lower courts are now grappling with challenges to laws involving firearm possession by certain categories of individuals, restrictions on specific types of weapons, and regulations on public carry. Some of these cases are moving quickly through the appellate system. Others may take years to resolve. So the story is far from over. Let me pause here and ask you something. Do you think courts should rely primarily on historical tradition when deciding modern constitutional issues? Or should they consider current societal needs as well? I'd be interested to hear your perspective, because this question goes beyond gun laws. It touches on how we interpret the Constitution as a whole. Now let's talk about what this decision does not do. It does not eliminate all forms of gun regulation. It does not create a completely unrestricted right to carry firearms anywhere, at any time. And it does not prevent governments from enacting new laws. It simply changes the standard those laws must meet. Understanding that distinction is crucial, because a lot of confusion comes from assuming the decision is broader than it actually is. In reality, it sets a framework, and that framework is now being tested in courts across the country. Another key point is that legal outcomes can vary depending on the specific facts of a case. Even under the same standard, different courts may reach different conclusions based on how they interpret historical evidence. That's part of how the legal system works. Over time, as more cases are decided, patterns emerge, and eventually, the Supreme Court may step in to resolve conflicts. Until then, we're in a transitional period. And for many Americans, That can feel uncertain, but it also highlights something important. Constitutional law isn't static. It evolves through cases, decisions, and ongoing interpretation. And understanding that process can help make sense of changes like this one. Before we wrap up, I want to address one final misconception. Some people believe that Supreme Court decisions instantly settle every legal question. In reality, they often raise new ones. The Bruen decision is a perfect example. It resolved one issue, the constitutionality of New York's licensing law, but opened the door to many others. And those questions are now working their way through the courts. So if it feels like things are still in flux, that's because they are. And that's a normal part of how constitutional law develops. Let's bring this all together. There are 3 key takeaways you should remember. First, the Supreme Court fundamentally changed the legal test for evaluating gun laws. The old balancing approach is gone, replaced by a history and tradition standard. Second, this shift has created widespread legal uncertainty. Courts are now interpreting historical evidence in different ways, leading to varied outcomes across the country. And third, the decision does not eliminate gun regulation, but it does reshape how those regulations are justified and challenged. Understanding these points matters, because constitutional law isn't just something that happens in courtrooms. It affects real people, in real situations, every day. Whether it's where you can carry a firearm, what restrictions apply, or how laws are enforced, these decisions have practical consequences. And the more informed you are, the better equipped you are to understand those changes. One final reminder, this video is for educational purposes only and not a substitute for legal advice. If you're dealing with a specific legal issue, a qualified attorney can provide guidance tailored to your situation. Thanks for watching, and if you found this breakdown helpful, feel free to share your thoughts below.